Good evening to all of you. Continuing from where we left yesterday, we were dealing with the conveyancing and we have dealt about 9 to 10 documents. The way conveyancing, these documents are drafted as per the law of conveyancing. Today we'll discuss what is called an LLP or what is called limited liability partnership. This particular document or this particular act came into force in 1969. It is something like a loose joint stock company where the partners inter se limit their liability and say that they are only liable for the liabilities to a particular extent. Here, this is very, very common in the business world, and where what happens is with limited investment and with limited liability, the business is carried on. Here, the same terms and conditions which are normally incorporated in the partnership deed is also forms part and parcel of the limited liability partnership. But only difference is that there is an extra, as far as the partnership deed is concerned, there is no limit as far as liability is concerned. I told you that the liability of a partner is joint and several. But in the limited liability partnership, what happens is they limit their liability and say to the extent of their contribution to the partnership firm, only to that extent they are liable, and over and above that, they are not liable. Each one limits his liability and says that only to this extent I will be liable to the other party. Not much of importance or not much of discussion is required, and the same process which you incorporate in a partnership deed is also forms part and parcel of the LLP. And LLP also can be registered, but what is registered is only the LLP firm and not the deed of LLP. The same clauses which apply to the partnership also applies to the LLP. The only difference being that the liability of the partners are fixed and they limit their liability, and only to that extent they make themselves liable. These are LLPs are today very, very common in the business world because what happens is it is run on mutual trust and confidence. That's the reason why they say it is limited for 5 years or 10 years, and after that they review it from time to time. Then the next document which we discuss is the will. As far as a will is concerned, will is supposed to be a testamentary transfer. All other transfers are all called non-testamentary. Non-testamentary means they come into effect immediately on the execution and registration of the document. But as far as the will is concerned, in Telugu it is called the Vilunama, and in Urdu it is called the Wasiyat. Here, will is the property which is sought to be transferred should be within the disposing capacity of the individual who executes the will, or the will is called the wasiyat or the vilunama. And normally, first and foremost, the theoretical part of it is a will. As there are two distinctions made, sir. As far as the Muslims are concerned, they can will away only one third of their property, but the other two thirds goes by inheritance. But as far as the Hindu is concerned, he can will away the entire property and settle the property in favor of his beneficiaries. And they're also called in law as a legatees. And a benefit that is given under the will is called a legacy. And one more important factor which you have to keep it in mind is because some ladies are also there, that normally the brothers play a confidence trick on the sisters. What they do is they ask them to sign as witnesses. Please remember, if any benefit is given to a daughter under the will, if she signs as a witness, she loses the legacy. Why? Because the presumption of undue influence will always be presumed, and she loses the right as far as the legacy or the benefit that is conferred. So, as far as ladies are concerned, I just advise that don't sign a will as an attestor. You will get into trouble tomorrow. And you will have to face the wrath of your husband also, who will say, who asked you to sign as a witness? So another question is, sir, who is a competent witness to attest a will? A competent witness normally is a person who is acquainted with the executant, or if he is a male, the executant is called the testator, and if she is a female, she is called the testatrix. And what is given under the will is called a legacy, or it's called a benefit. Here, the will to be executed and the property that is sought to be settled should be within the disposing capacity of the individual who executes the will. Because of the maxim nemo dat quod non habet, the question is no man can pass a better title than what he himself has. So this has to be borne in mind. And second thing is a distinction has to be made regarding Swarjitam and Purvajitam. That is, Swarjitam means self-acquired and Purvajitam means what comes from the ancestors. As far as the self-acquired property is concerned, there is no bar for a person executing a will. He can give it to anyone he likes. But as far as ancestral property or proportionary property is concerned, where the shares are already fixed and the property is not earned by the testator, but it has come to him from his ancestors, then in that case, it is always open to be challenged because the other sharers who are entitled for a share, they can definitely reopen the will and question the will and also challenge it in court. Here, the word that is used is in, please remember, in sale deed and other documents, we use the word transfer. But in a will, the word that is used is bequeath, Bequueth. And the benefit is either called a legacy or it is called a bequest. First and foremost is where the will is executed has to be clearly mentioned. This will executed by me at Secunderabad on this the day of so and so. Then the name of the person is there. Mr. A, son of so and so, age so and so, occupation so and so, resident of so and so. Then next para, you say, whereas I have 4 sons and 3 daughters and a wife, and I have I have amassed a properties, the descriptions which are given during my lifetime out of my own earnings. Next para. Whereas to avoid bickerings, differences, and disputes between my sons and daughters and my wife, and in view of my indifferent health and medical ailments, I've got all. I mean, I feel that I may not live for long, so I desire to bequeath and settle my properties in favor of the beneficiaries in the manner hereinafter mentioned. Next para. Whereas my eldest son, so and so, is looking after me in my old age and is also looking after myself and my wife during my life, during my ailments, and is attending to all my physical and medical needs. And I therefore desire that I have to provide some property to him by way of this bequest, and hence I am hereby bequeathing house number so and so, house number so and so, admeasuring so and so, situated in so and so place to my eldest son. Absolutely. Then next para is whereas my second son is so and so, and I desire to bequeath or settle some property on his name, and therefore I am settling the property mentioned in the schedule number B to my second son. Absolutely. Like that, third son, fourth son, and so on and so forth. Then, whereas I have 3 daughters and I have performed their marriages with my earnings and savings and the jewels of my wife, and all the jewels and ornaments have been given to my daughters, and I do not desire to give any property to my daughters. Then next para is whereas it is my desire that my children should live amicably and cordially and should not quarrel between themselves and maintain the cordiality and the prestige of the family after my demise. Next para is whereas I I anticipate that because of my illness and because of my ailments and physical disabilities, I may not live long. And after my demise, in case my wife survives, a life interest is created in respect of this property, a particular property, in our favor till her lifetime. And after her lifetime or before her lifetime, it is open to her to settle the properties in favor of any of my sons or any of my daughters. Then the next one is you mention is this will is my last will and cancels and modifies all the previous wills and codicils, if any, and this shall take effect immediately on my demise. And next para, what you write is that I reserve my right to cancel, vary, modify this will anytime during my lifetime. And then you also say, in witness whereof I have set my hands and affixed my signature voluntarily without any compulsion or force in a sound disposing state of mind. And then the testator or the testatrix signs the document, that's executed rather, and it is witnessed by two witnesses. Then I'll give you the significance of these witnesses. They are called in the law of evidence as the attestors. Attestors mean that the executant or the testator or the testatrix is well acquainted with him and that he has seen the testator or the testatrix put his signature on the document. And after the testator or the testatrix signs, he or she countersigns the document as an attestor. And second attestor also there. Then who are the attestors I should choose, sir? Normally, there is a misnomer among parties. Already the testator is about 98, nearing 90 years. Then the sons and daughters feel, let us take the signature of a witness who is 95 years. Please remember, the lifetime of this testator, lifetime of this attestor is very much doubtful. When the testator himself is 90 and the attestor is 95, you say that we are giving a lot of respect for an old age person, and a person who attests the document is a genuine person, and his signature will be believed by the court. Please don't make that mistake, sir. If you make that mistake, you run the risk later. Why? Because the question is choose young people who are the witnesses, because this is called a testamentary transfer. Testamentary transfer means, why I'm using the word testamentary transfer is Mr. Sam is also one of the participants here. Among Christians, they use the word testament. It's Old Testament and New Testament. I don't want to go to the religious aspect. But here, a will comes into effect after the demise of an individual. It does not come into effect during the lifetime. But a non-testamentary instrument like sale deed, gift deed, so on and so forth, it comes into effect after immediately on the execution and registration of the document. So it is advisable to take young people as witnesses who are trustworthy witnesses, who are well known to the executant, who are well known to the family, and one of the family friends as far as the family is concerned, so that tomorrow, if the will is called in question, normally, please remember, the avarice of human beings is such that at every available opportunity, everyone wants to amass property and to the detriment of his brothers. And please remember, there is no affection or love as far as property is concerned. In Tamil, they say, if money is shown or money is talked about, even a corpse will wake up and say, where is the money and all, because that is the love and lust as far as money is concerned. So please be very careful when you choose an attestor or two attestors, and those people should be young enough so that whenever the will is questioned, it will not be questioned in the lifetime, but after the lifetime, when it is questioned by one of the beneficiaries, then in that case, these attestors should come to your rescue and say, sir, we admit that we know the signature, we are acquainted with the signature of the testator or the testatrix, and in our presence, the testator or the testatrix has signed, and after the testator or testatrix has signed, we have countersigned it as having witnessed the execution. And under the law of evidence, more particularly the law relating to attestation, to what extent you can examine an attestor. And please remember, in all cases where the will is set up and the person claims under a will, attestor has to be compulsorily examined. It is not necessary that both the attestors should be examined. If one attestor is examined, the question is, it is sufficient. But the question is sometimes, the integrity of the attestor also cannot be believed. I think in previous class or somewhere, someone asked me, sir, if one of the attestor turns hostile, then what is the position? You can always examine the other attestor. Nowhere in law it is said both the attestors will have to be examined. But the question is, what will be the scope of the attestor's evidence? Attestor will come and say, sir, I'm acquainted with the family of the testator or the testatrix. I know the family very well. I can identify the signature of the testator or the testatrix. I can identify the handwriting of the testator or the testatrix. I am well acquainted with that, and we are having cordial relationship. And after the testator or the testatrix signed, I countersigned it as having witnessed the execution of the document. That's all. But sometimes what happens is we advocates also make a mistake, sir. What we do is, if this is the scope of an attestor's evidence, we go into the merits of it, we go into the contents of the document, we go into which property is given to A, which property is given to B, which property is given to C. And please remember, an attestor need not speak about those facts. It looks very unnatural that the attestor knows what are the properties that are bequeathed. He only countersigns it as having witnessed the execution. So this is, but please remember, as far as a will is concerned, will has to be compulsorily attested by two witnesses. Then the question arises, sir, is a will compulsorily registrable? Section 18 of the Registration Act says registration of a will is optional. It may or it may not be registered. But one advantage of registration is that it becomes a public document, it comes into the public domain. Anyone who wants a copy of that document can apply to the registrar and get a copy and get himself satisfied about the contents of the will. Then this is as far as a will is concerned. Are you able to follow, please? And the question arises, sir, what is the distinction between a Hindu and a Christian? But as far as the Hindu is concerned, a will need not be registered. But if an executor is there who is appointed for the purpose of implementing or giving effect to the will, all the powers are given to the executor to distribute the property after the demise of the testator or the testatrix. Then the question arises whether the will is to be registered. Then, but will need not be registered, but the probate has to be obtained. And probate, as far as Hindus are concerned, it applies only to the presidency towns like Chennai, Mumbai, and Kolkata. But as far as the provincial cities are concerned, registration of a will is not compulsory, or probate is not compulsory. But I will come to Christians. As far as a Christian is concerned, a Christian will has to be compulsorily registered, and it has to be attested and in all respects, and it has to be presented for registration. And then after that, you have to file an OP, or what is called original petition, before the district court for letters of administration to implement the will. So, as far as Christians are concerned, a Christian will has to be compulsorily registered and letters of administration has to be obtained. Then the question arises, sir, that suppose I ask for probate, let us say, just for argument's sake, suppose, because let us say the executor says whatever benefits are given under the will, under the will, don't disburse the benefits till you hear from me. That is, in other words, by his letter, he freezes the benefits of the beneficiaries. Then, in that case, the bank to which it is referred, the bank insists, since the executor has written such a letter, we are not going to give you the money, you go and obtain a probate from a district court. Here, one thing you must remember, sir, previously, be it a presidency town or a provincial town, the question is district judge had no powers. But one of the judgments of our High Court, Andhra Pradesh High Court, the composite Andhra Pradesh High Court, if I am correct, it is the judgment rendered by Justice Ghulam Ahmad and Apparao, which says that as far as Section 50C of the Indian Succession Act is concerned, if though the executor is appointed, the probate can be obtained from a district court. But please remember, it's a very costly affair, sir. The valuation of the property, and you deposit 6% of the value of the property into the court, which goes to the state, and 10 rupees you are fixed on the OP which you file in the court. I still remember I conducted one of the cases in a district court where what happened was a particular, I think most of you are aware of, a reputed company called Binani Cement. In Binani Cement, there is one old lady who was called Govind by Binani. She executed a will whereby she had assets worth about, I think if I'm correct, it's about 10 to 12 crores. And out of that, she gave the eldest daughter 3.5 crores, the second daughter 3.5 crores, the third daughter 2.5 crores, and as far as the fourth daughter is concerned, she gave her immovable property to that lady, which was a three-storied building, and it's a very reputed locality that is beyond the shopper stop, Begumpet, or police near police lines. And as far when the application was made to the bank to pay the fixed deposits, the bank raised an objection. The executor has addressed a letter not to disperse the benefits till they hear from him. You go and obtain a probate from a civil court. Then the question arose. We filed a petition for probate under the Indian Succession Act before the district court. And the district court concerned, before whom the matter had come, had just asked me a question, sir. Are the parties Hindus or not? Yes, sir, they are Hindus. Then why did you ask for probate being granted? Then I said the executor has addressed a letter to the bank not to make the payment till they hear from him. And the question, since a dispute is raised, the bank has not paid the money, so the bill has to be implemented. Fortunately for me, what happened was the person who executed, the executor had to be examined, and the executor belonged to Kolkata. And please remember, I wanted to expedite the matter as far as possible. We got a commission appointed and examined the test executor in Kolkata. And then the attesting witness who was there, as far as the will is concerned, happened to be the accountant of my client, that is the one of the daughters. And he also gave his evidence, and both the witnesses were examined. Ultimately, the matter was argued and probate was granted. Then the judge asked me a question, sir. Why did you ask for probate? Among Hindus, probate is not necessary. You should have made the bank. That is, I think, if I'm still correct, it is Hindus in the bank. They said you should have implemented that bank. I would have awarded costs as far as as for against the bank if that was the scenario. Then I told the judge in a humorous way, sir, if everything had gone on well, where would I be? I would not get my fees. I would not get a brief. So the question is, thanks to the bank, because that objection was raised, I got my fees and I got a brief. Well, these are all things which happens in the practical outlook, sir. So probate is absolutely not necessary as far as Hindus are concerned, but as far as Christians are concerned, a will has to be registered and letters of administration has to be obtained. But in the presidency towns, a will has to be, unless you obtain letters of administration, the benefits under that will cannot be disbursed. That is only in the presidency towns, not in our provincial towns. And now, as per the present judgment of our AP High Court, the question is the petition for probate or letters of administration can be filed before the district court and not before the High Court. Because here, please remember, whether it is Andhra Pradesh or Telangana, High Court has no original jurisdiction. Only the presidency towns, they have got original jurisdiction. Suits or OPs can be filed before the Honorable High Court at the particular place. Then we come to one term called codicil, 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 codicil. Codicil means suppose certain errors or omissions have occurred in the original will which has been registered, you cannot correct it with your pen because the corresponding copy will be in the records of the registrar. Or if it is an unregistered will, also the question is there are some errors and omissions. Already it has been signed, already it has been executed, already it has been attested, but you cannot make any corrections or alterations in the document. The only remedy open to you is to, or let us say, some properties remained unsettled. That is, some properties have got missed as far as the original will is concerned. Then, in that case, you draft a document called codicil, CODICIL. That is, wherever errors have occurred in the parent document, that is the original will, you get those errors corrected. And also, what are the properties that have got missed in the original document, you incorporate it in the codicil, and also say that this codicil in no way repudiates the original will already executed, barring the corrections and alterations which have to be made in the parent document and cannot be treated as repudiation of or revocation of the original will. Then the person who executes the will signs the document and along with the parent document submits it, copy of the parent document, submits it to the registrar for registration. And then this codicil will be also registered and will form part and parcel not only of the parent document that is called the will and also the supplementary one that is called the codicil. That is what codicil means. Codicil is meant for correcting the errors, correcting the omissions, and properties which have not been mentioned in the parent document. You add it here, and to whomsoever you want to give it, you can mention it. And the registrar cannot refuse registration, but he has to register the document. Something like in an agreement. I told you also when we discussed the agreement of sale, sometimes what happens is a supplementary agreement also is made. But please remember, once a supplementary agreement is made, it is in addition to the original document. It does not substitute, it does not cancel the original document. Only thing is certain things are added which was not found in the original document. This is as far as a will is concerned or a codicil is concerned. Then, what we did not discuss by inadvertence or oversight is lease, 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 lease or rental agreement. Here, one thing you must remember is in a sale deed, what is transferred, sir? In a sale deed, what is transferred is title, proprietary rights, as well as possessory rights, or as far as possession is transferred. Ownership is transferred from a person called the vendor to a person called the vendee for a consideration called the price. In a gift, what is transferred? What is transferred is a benefit is conferred by the donor to the donee out of natural love and affection. It also amounts to what is called transfer. Then family settlement, so on and so forth. Here, the question is as far as the lease deed or rental agreement is concerned, you must know who executes it in whose favor. Suppose you are aware of the Contracts Act, more particularly section 176 or 178, it defines what a pledge or pawn means. Here, pledge or pawn means where movable property is offered as security for the due repayment of a loan paid, promised, part paid or part promised. It is called a transaction of pledge or pawn, and the person who offers the property, movable property as security is called the pledgor or is called the pawner, and the person to whom the property, movable property is offered as security is called the pawnee or is called the pledgee. And mostly this case of pledge arises in respect of gold loans. I think you know, whenever you want a loan, when you don't have money, you pledge your jewels and it is properly valued. And according to that, the grams, so many grams it is there, and your money will be paid, and you have to repay it within a period of 2 years or 1 year, however you want to pay. Then the question is, there is still such time you repay the money, the property will not be delivered to you. And in other words, the pawnee or the pledgee comes into possession of mobile property which is entitled to retain till such time the entire loan is liquidated. Here, in the same way, please remember, please underline the word mobile property. But here I've also to define what is meant by hypothecation. Hypothecation, when we come to the Transfer of Property Act, we will discuss it in detail, but it is suffice for you to understand that hypothecation means pledge of immobile property. For example, suppose you want to set up an industry or you want to set up a printing press, the machinery is a mobile property. I think most of you admit it also that machinery is supposed to be a mobile property. But once it is fastened to the earth with nuts and bolts, it acquires the characteristics of immobile property. That's why it is called pledge of immobile property is what is called a hypothecation. And the property which is hypothecated or pledged is called the hypotheca. And the transaction through which this is done is called hypothecation. That is why I'm talking it as pledge of immobile. Pledge of immobile property means this, once the nuts and bolts are removed and it is unfastened, the machinery can be removed and shifted. So there is no permanency as far as the machinery is concerned. The initially what happens is the machinery is purchased out of the with the bank loan, and with the bank loan you purchase the machinery. It is fastened with nuts and bolts, and then when it's not fastened with nuts and bolts, it remains a mobile property. But when it's fastened with nuts and bolts, it is attached to the earth, fixed to the earth. It acquires the characteristics of immobile property. That is why what is originally pledged is the mobile property. That is the printing press, printing machinery. And once the printing machinery is fastened to the earth, where you carry on business, it acquires the characteristics of immobile property. That is the reason it's something like hypothecation is nothing but a hybrid transaction. Then, having a background on the Contracts Act, we go into the law of leases. Please remember, in Andhra area, there are three documents which are executed. Normally, three documents are prevalent. One is called lease deed, another is called a rental agreement, and another is called a rent note. Rent note, I'll come one by one. Rent note is nothing but, most of you know that nowadays printed books are available as far as rent receipts are concerned. And there, they are beneath the original, it will be written TNC appraisal. Then on the reverse, if you see the terms and conditions as far as the tenancy is concerned, will be mentioned. That is called a rent note. Then, as far as agency areas are concerned, and on one more thing is also prevalent in Telangana area and all, we call it as a kaul nama. Suppose you have got agricultural land, you are not cultivating the land yourself, but you are giving it to a tenant to cultivate, or a tiller to till the land. He is called the kauldar, and the document that is executed is called the kaul nama as far as Telangana is concerned. But agency areas and all, they use the word pauthi, P-A-U-T-H-I. Pauthi means it is given on lease. And as far as the Urdu term is concerned, it is called the kabuliyat, K-A-B-U-L-I-Y-A-T, kabuliyat. So these are the three terms which you have to remember. Now we go to the lease deed and rental agreement. As far as the rental agreement is concerned, please remember what is delivered under the rental agreement is right to possession of immobile property is, or even mobile property also you can say, is delivered by the landlord to a person called the tenant on certain terms and conditions, on condition of payment of rent, share of crops, annuities, profits arising out of the business. Such a person is called the landlord, and the person to whom possession is delivered is called the tenant. And a rental agreement is executed on a particular day by the tenant with his full description in favor of the landlord, whomsoever's name it may be. Then the preamble will say, whereas the landlord is the absolute owner and possessor of house number so and so, admeasuring so and so, comprising of ground and first floor by virtue of a registered sale deed bearing document number so and so. Next, whereas the tenant in desirous of a rented accommodation for his business purposes or for his residential purposes has requested the landlord to let on rent the premises belonging to the landlord on a monthly rent of rupees so and so. Next para is, whereas the landlord has accepted the request and offer of the tenant and agreed to let out the premises number so and so on a monthly rent of rupees so and so, exclusive of electricity and water and maintenance charges. Next para is, whereas the tenant has this day deposited a sum of rupees so and so towards advance and earnest money, which sum shall be refunded at the time of vacating the tenanted premises. The next para is, whereas the landlord admits and accepts the receipt of rupees so and so by way of advance and earnest money, and agrees to refund the said amount after settlement of accounts once the tenant vacates. Then we say, now this agreement witnesseth as follows: that the tenant shall pay a sum of rupees so and so towards monthly rent to the landlord exclusive of electricity and water and maintenance charges. Second one is in addition to the rent on or before 5th of every English calendar month and obtain receipts. Second clause which will write in a rental agreement is the tenant also agrees to pay the municipal taxes to the corporation every half year or every 1 year, and the landlord shall not be responsible for the same. Please, I'll come to it also. Third one is where when the landlord has this day delivered possession of the schedule mentioned property to the tenant for a period of 11 months or 12 months, whatever it may be. So then next for the only residential or non-residential, whatever. Then next one is the tenant shall not make any additions or alterations or structural changes to the tenanted premises without the written consent of the landlord. Then next one is that the tenant agrees not to sublet or assign his tenancy rights without the express consent of the landlord. Then next one is the tenant agrees to use the tenanted premises only for residential purposes and shall not use it for any other purpose which is not mentioned, which is not the terms of tenancy. The next one is that the tenant has this day paid a sum of rupees so and so towards advance and earnest money, which sum shall be refunded by the landlord in the event of the tenant vacating the tenanted premises. Next one is that the tenant agrees to pay a sum of rupees so and so towards monthly rent and agrees to for a monthly rent and also agrees to pay and enhance the rent by 7% or 8% once the tenancy is extended for a further period or periods. And then the next clause, also safe clause you write is notwithstanding anything contained in this document, in case the tenant commits a default on payment of rent for 3 continuous months, he shall be liable to be evicted without any further notice. And then next one is in case both the parties desire to put an end to the tenancy, it shall be done only by 3 months advance notice in writing on either side. And then next one is the question is the tenant agrees to utilize the tenanted premises keep the tenanted premises in a neat and habitable condition and shall allow the landlord to inspect the premises at all reasonable times after prior notice. Then in witness whereof the tenant has set his hand and affixed his signature voluntarily without any compulsion or force, and then the tenant signs and the witnesses also attest the document. But please remember, as far as a rental agreement is concerned, a rental agreement is supposed to be only a unilateral document, only the tenant signs. But now the fashion seems to be even the landlord is also signing the rental agreement. Please remember the tenant executes it in favor of the landlord, not the landlord and tenant agree. Then here comes the distinction, sir. Then we go to the lease deed. What is the difference between a lease deed and a rental agreement? Lease deed is supposed to be a bilateral document. A bilateral document means it is executed by the lessor in favor of the lessee, and there are mutual conditions, mutual obligations by the lessor and mutual obligations on the part of the lessee. So all the clauses will be there, but who should pay taxes? Then what are the duties? What are the duties of the lessor? What are the duties of the lessee? All those things will be incorporated, and the lease deed is executed accordingly, and it is signed both by the lessor and the lessee. Now I think after the Modi government had come into power, and even earlier GST was introduced. That is, they say whenever you take advance, whenever even in respect of immobile property, you have to pay the GST also. Even in respect of sale deeds also, the purchaser becomes liable to pay the GST and the seller also becomes liable to pay the GST. That is, in other words, it was remarked very in a comical way to say GST means Gabbar Singh tax, but you cannot avoid. Even if a water bottle is purchased by you, GST is attracted. You cannot avoid GST. That is taxes on goods. So the question is, the lessor signs and the lessee signs, and also it is witnessed by 2 witnesses. And it's also safer to, please remember, I've seen Karnataka. In Karnataka, what happens is the furniture that is given, the fittings which are there, the fixtures which are there, the wash basin which is there, the closet which is there for toilet, etc., the color of the toilet, color of the wash basin, the color of the walls, and all things will be mentioned in the Schedule B. And when the tenant vacates, he has to hand over the premises in the same condition as it was when it was let out. And question is, your advance will not be returned till such time you put it back in the same position. But we are very very what is called liberal as far as Telangana and Andhra is concerned. We don't mention all these things. We think it is too small. But sometimes what happens is, once the tenant vacates, what happens is he pulls away the tube lights, he removes the fans, he removes the electrical fittings, and keeps the premises in a very shabby condition. So that in Karnataka you cannot play with the landlords. In Karnataka, whatever, suppose your walls are green color, you must have the green color only. And if your wash basin is green color, you must have the green color only. If your closet is green color, you must have the green color. You must restore it to the same position when it was let out. Without that, you will not get your advance. And please remember, that's why it is said that uh, as far as Andhra Pradesh is concerned or Telangana is concerned, we are what is called in Telugu they say Petandala Rashtralu. ఎందుకంటే the question is here mostly law is tilted more towards the landlords rather than the tenants. But as far as Karnataka is concerned, or Chennai to, for the matter of fact, it is very difficult to get a tenanted premises. And even if you get a tenanted premises, most of the judges who are occupying it are all tenants. So there, if you see in Karnataka, the judgments are mostly tilted more towards the tenants rather than the landlords. But here, if you see our Andhra Pradesh, the question is it is tilted more towards landlords because personal prejudices also come into the picture. I still remember the person who drafted the Rent Control Act in 1960. He happened to occupy all important positions in the government till the position of a chief justice. He had houses, multiple houses in Kachigoda. He could not get rid of the tenants for the 35 years, and ultimately he was asked to draft the Rent Control Act, and he drafted the Rent Control Act in such a way that it benefits landlords by saying, even if I have 10 houses, you cannot dictate which house I should occupy, but I prefer your house only, which is more suitable for me. The tenant cannot dictate terms. So then again, so many things are there. If you see our judgments of our High Court, and more particularly, if I'm correct, it's 1971 AP, the judgment rendered by Justice Ramchandra Raju, who said, tenant cannot dictate terms. It is for the landlord to choose. So long as the right to property is recognized, the tenant has no business to dictate terms to the landlord and say, occupy this premises or occupy that premises. So the judgments here in Andhra Pradesh, as far as Telangana is concerned, it is more tilted towards landlords rather than tenants. But in Karnataka and Tamil Nadu, it is tilted more towards tenants because judges are tenants. That's why I said justice varies according to the foot of the chancellor. So here, the question is we have to be very, very careful. You'll have to say when the lease has commenced. Lease has commenced on 1/12/2000, let us say. It remains in force for a period of 11 months. It expires on 30/11/2000 next year. And then the new lease comes into play the next year. Then if you see the repercussions or the what do you call amendments to the Registration Act, Section 17B says, after the amendment in 2001, all leases which reserves an annual rent or which involves a property, immobile property, has to be in writing and has to be duly registered. Even if it's for 1 month, even if it's for 2 months, it has to be registered under the law. Without registration, the document cannot be looked into for a primary purpose. Gone are those days. Someone asked me also, I think in the previous classes, sir, we draft a document lease for 11 months. We draft it for 11 months because earlier to the amendment, it didn't require registration, but it required the proper stamp duty that has to be paid. And the stamp duty that has to be paid in respect of a lease deed or a rental agreement is 3% of the annual rent. If it is for less than 3 years and above 3 years, it is 5% of the annual rent that has to be paid by way of stamp duty, and 1% registration is collected. Registration fees is collected by the registrar. Please bear one thing in mind. Most of you are advocates. Be very, very careful as far as this point is concerned. Please remember, I think someone asked me, sir, These companies, what they do is 10 rupees or 50 rupees, they draft a document. So long as there's no dispute between the landlord and the tenant, there's no problem at all. But once the dispute start, if please remember the tenant takes all defenses possible. Sir, it is not properly stamped. Now the landlord takes a not properly stamped, it is not registered, it's unenforceable. Then you get into a soup. So that is the reason. Be very, very careful. And always when you see a document, please look into that 17(1)(b) of the Registration Act, whether your document requires registration or not. So this is as far as a lease deed is concerned, or what is called your rental agreement is concerned. Then you have got one more document which is drafted, is called hire purchase agreement. I think loosely it is called the contract of leasing between the lessor and the lessee. Please remember, if you see the paper every day, what do you call this? Hire purchase agreements are made. That is, you don't pay the money. Hire purchase agreements normally take place. I think it's my understanding. It takes place as far as mobile property is concerned. You go to Bajaj Electronics, and then what you say is you purchase a TV, you pay only 1 rupee, and the rest of it you pay by way of EMIs, and you give PDCs. PDCs or post-dated checks. On the due date, the check has to be honored. So in those cases, what happens is the property in goods or the ownership does not pass on to you till such time you repay the amount that is due towards the purchase. And the person who gives you the possession of the property is called the hirer, and you are called the person who has received the property. And even in what you call Woodco and other banks also, housing loans or home loans are given. You do not become the owner of the property, but you only become the possessor of the property. And as far as the EMIs are concerned, you are supposed to pay every month for a period of 60 months or 48 months as you have chosen. So these are all the various documents which come under the law of conveyancing. Then when we come to the Companies Act, there are two documents which are normally found in the Companies Act. They are called and popularly called the Memorandum of Association and Articles of Association. As far as Memorandum of Association is concerned, it is supposed to be the heart of the company. And you know, without your heart or without your brain, you cannot function. Your human body doesn't function. So, Memorandum of Association is name of the company, place where the registered office is located. The objects are there. Next one is the objects with which it has been incorporated, ancillary objects which has been done, the powers of the director, so on and so forth, will be incorporated in the MOU. And in the MOU, mostly what is important for all of us is that the objects clause is very important. That is what is called the Lakshmana Rekha as far as a company is concerned. The company cannot go beyond the objects clause. Suppose a company is formed for purpose of construction of buildings, it cannot go for construction of bridges. That is alien to it. Unless it is incorporated in the objects, that means anything which is beyond the objects of the company enshrined in the Memorandum of Association is supposed to be ultra wise. And in those cases, the corporate veil or the burqa as it is called, or even you can call it as hijab, can be pierced, and then you can look into the character of the company and make the company liable for having crossed the line which is not provided in the objects clause. Then articles is the internal regulations of the company, where the powers of the director, the qualifications of the director, how shares are allotted, what type of shares are allotted, who is the signing authority as far as checks is concerned, who is the signing authority as far as operating bank accounts are concerned. All those things will be mentioned in the articles of association. But you need not go into the drafting part of it because it is not part and parcel of our discussion. Then next last document which is left is exchange deed, which is very, very rare. In exchange deed, there is no consideration at all. What happens is, suppose A is the owner of property X and B is the owner of property Y, and let us say A exchanges the ownership of property X for property Y, and Y gets the B exchanges the ownership of property Y for getting property X. And exchange deed is almost the same as far as the sale deed is concerned. Only thing is you mentioned two schedules whereby what A gets and what B gets, you mentioned that is exchange of ownership between two people who are the owners of different properties. That is called an exchange deed. In all these documents of conveyancing, if the immobile property is involved and it amounts to transfer of immobile property, it requires stamping and it requires registration, and without that, the document cannot be looked into for a primary purpose. I think this finishes the law relating to conveyancing. And next, we'll discuss about drafting and pleading later, or I'll just give an introduction to that and then stop. Here, as far as drafting and pleading is concerned, drafting does not come to everyone. Drafting is an art. Drafting is a science. Drafting has to be perfected by experience, not by looking into books and not by reading articles or not by attending seminars. Drafting is the pen power as far as the person is concerned. Here, I'm only giving an introduction piece, I have not come to it. Here, we have got two systems of drafting. One is called the Anglo Saxon method, and another is called the American method. As far as the Anglo Saxon method is concerned, it means right from the first word to the last word, blah, blah, blah. It is English method that is called Anglo Saxon method that is followed by the Commonwealth. Then, as far as the American system of drafting is concerned, it is called short sentences, short paragraphs, which has more clarity and which is more clear and up to the point. It is called the American system of drafting. Then, when you ask me to have a choice between the American system and the Anglo-Saxon method, I would advise that American system is a better system because normally you don't carry on your advocate's profession single. You have your colleagues, you have your juniors, then you depend on your juniors. So they say American system says, suppose you've got 15 documents, you devote one paragraph each for each document so that even if you are not there, your juniors can go on with the case. But in America, in English, the Anglo-Saxon method, what is there in Telugu? They say Antam Kadidi Arambam. It is something like our films today. We do not know where it has started, where it has ended, what is the interval time till what the movie has gone, and so on and so forth. It should not be so. What happens is the judge must be in a position to understand. Judge must be able to assimilate. Judge must be able to appreciate. You as an advocate also should be able to explain to the court as to what are the contents as far as your plaint is concerned. That's why it is said drafting does not come immediately. Drafting has to be practiced for a long time, and by experience and usage and following the drafting of certain your seniors or the old drafts, please remember you can perfect drafting is concerned. So pleading is something different. Only I'll give an introduction, please. I'm not going to the subject. As far as pleading is concerned, pleading is defined under the Civil Procedure Code as meaning both the plaint as well as the written statement. Here, side by side, we'll have to discuss what are the essential ingredients of a plaint, what are the essential ingredients of a written statement, what are the essential ingredients as far as a set off is concerned, what are the essential ingredients as far as a counterclaim is concerned, and so on and so forth. So the question is how to understand it. Please remember reading any number of books, reading any number of newspapers, reading any number of treatises, or having your formats from your seniors, or following the Google for the purpose of drafting pleadings or for the purpose of drafting purposes will not take you anywhere because the facts and circumstances differs from case to case. You will have to mold it in such a way that it fits your case. And you must also, when you draft it, you must also consider it from the viewpoint of the opposite side and have a mock drill in your office. And if you are practicing on the trial side, you must always have the client with you at the time when you draft it because there are certain facts, there are certain truths which are known only to your client, not to yourself. And please remember when you draft a particular plaint or written statement, be very, 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 very courteous. Don't try to make defamatory allegations. Don't try to make insulting allegations. Don't try to make annoying insinuations against the opposite side. And when you're giving a notice also is a clever drafting. In that also, suppose some allegations are made like unchastity, so on and so forth, you take the signature of your client and then you also sign. Why? Because tomorrow your client at the earliest available opportunity will say, Sir, nakem telosa na pleader gare rasaranta. So that the entire blame is put on you. So you have to guard yourself against such people in future. I think with this, we'll stop today and we now go to the interaction period, please. అదే అవి డోర్ తర్వాత చెప్పినాను.
Sir, you can go ahead.
The question now starts, please.
Good evening, sir.
Yes, good evening. Yes, sir.
Sir, it's regarding the will. As you said, two attestors are compulsory.
Yes.
If both the attestors are not existing, then it is actually the dispute arises. So
I think this question was asked by you only in the previous 2-3 classes. Here, suppose the attestors are dead and gone. What you're trying to mean is that not available will not apply, sir. Or let us say they are gone where you do not know their whereabouts. I think you are trying to ask that question. Then in that case, any person apart from the attestors, their family members or any outsider who is acquainted with the family who can identify the signature of the testator or the testatrix can come and give evidence and identify the signature, number one. Or under the old Evidence Act, section 73 and 74, the court can itself compare the signatures through admitted documents as well as the will and come to a particular conclusion regarding a particular will. That's why I said choose attestors who are trustworthy, choose attestors who are young enough, choose attestors with whom you can have confidence and will come to your, because please remember, will is a controversial document. It comes into existence after the demise of an individual. That is the reason attestors should be sound. I'll tell you, there is an example, I think in Andhra area, there is a district called Prakasham district. Most of the cases which are reported as far as forgery is concerned is from Prakasham district. Suppose a promissory note is introduced. What happens is the person who is the opposite side admits the promissory note, but he brings another promissory note and says, sir, all the obligations under the old promissory note is discharged by virtue of this document. He puts the signature of the promisee also there. That document also is a forgery. This document also is a forgery, resulting in 4 litigations coming up. One is forgery by the person concerned who is the promisee, forgery by the person who is the promisor. So what happens is one litigation lands itself into 4 litigations. If you look into the ARs and the Andhra Pradesh journals, most of the judgments on forgery is from Prakasham district. I think some of the candidates are from Prakasham district also. That's the reason why I'm referring to it.
The second question is, it is with respect to, in case of if the DKT DKT land has been specified in the will and it has been registered. So in that case, okay.
Please remember, only the occupancy rights can be transferred, sir. But if you see the D Patta, or D Patta is what is called 60 yards or 80 yards is given by the government to the landless poor. That cannot be alienated, that cannot be transferred for a period of 10 years. After 10 years, you can take the permission of the collector and alienate that property. But the question is, now the present government is thinking in terms of regularizing all Leone Pattas and even D Patta lands. And D Patta's lands are also being mortgaged also. I think perhaps you know about it. And D Patta lands, normally the registration is refused. Only notary signature will be there.
Sir, if it is not a D Patta, and for example, if the land has been
assigned,
not given Patta by the revenue officials.
Let us put it this way. It's an assigned land, let us say. In Telugu, they call it as Leone Patta or Lavanya Patta. That is, it is given to the landless poor. And now the present government is embarking on an activity of providing Indirama Illu. There also what they do is, they only execute what is called, the patta is given. No document is executed. They are given right of occupancy because they don't have land or they don't have property. But you cannot sell that property without the permission of the government. Are you able to follow, sir?
Yeah, sir. In case if it is purchased from
no title.
other people from long back, it was in possession.
Even then, you have to plead what is called adverse possession. That is more than 12 years.
If at all, as I said, okay, if it is adverse possession and it was specified in the will and it has been registered.
Yes.
By some influence, it was registered. Then
you cannot go back on the registered document unless the other beneficiaries question it.
Okay. Then the title can be transferred, sir. With
title is an imperfect title, sir. It's only a possessory right that can be transferred, even if it's an alienation. Only possessory rights can be transferred, not the title or rights.
Okay, sir.
Right.
Thank you, sir.
Hi, Mr. Venkatesh, 1 minute. Here there is one area called cantonment area in Secunderabad, where the paramount title vests with the government, and you are only the owner of the superstructure, not the land. And that is the reason, before applying for layout and all, you have to execute a gift deed in favor of the cantonment board, saying that 1/3 of the property has to be gifted to the cantonment, to the defense estates officer, for the purpose of providing common amenities like temple, church, gurudwara, or a mosque and a park. That area cannot be sold. It vests with the government. But as far as the other area is concerned, it can be sold. You are only you are only a lessee, and you are not the absolute owner. That's the reason it is said the paramount rights as far as the land is concerned, it vests with the government, and you are only the owner of the superstructure. That is the reason it is said government tries to collect taxes from you by way of property tax, so on and so forth. That is the reason you recognize the rights of the government as far as the land is concerned. And I just remarked in a jocular way, like Alauddin's lamp. Suppose the government imposes tax, let me shift that house, lift it in the sky, and occupy in a place where there's no tax imposed.
So, thank you.
Next, sir.
Good evening, sir.
Good evening, Mr. Prasad.
Yes, sir. Kindly explain about probate.
Sir, as far as probate and letters of administration is concerned, giving official sanction or official recognition to the will executed by the testator or the testatrix, whereby benefits are conferred on the beneficiaries or the legatees, as they are called, and the legacies are implemented by giving by approval by the court and the seal of the court. It becomes a judgment in them. That is what is called probate. And as far as Christians are concerned, the same procedure is there, but a Christian will has to be registered, and then you will have to apply for letters of administration. But a will need not be compulsorily registered under Section 18. But the advantage of getting it registered is it comes under the public domain, and it's a public document. And whenever an unregistered will is produced, the registered will prevail over the unregistered will, sir. And probate is defined as giving an official recognition to the desire of the testator or the testatrix by putting the seal of the court and giving him something like what you call it as patta or whatever it is. He becomes entitled to that property. It's almost a title as far as the property is concerned, which has come to you by way of a bequest by the testator.
Okay, sir.
Good evening.
Good evening.
Second one, sir.
Yeah.
Can you please also explain about the roles and duties of the executor of will? Actually,
yes, sir. As far as an executor is concerned, normally the executor is a person is appointed by the testator or the testatrix in whom he has got confidence, who is a family friend or a relative, or he knows the entire family, or he is in good books with all the beneficiaries or the sons and daughters, and he implements the will or the desire of the testator or the testatrix and hands over the properties to whomsoever is concerned as per the desire of the testator or the testatrix. Such a person is called an executor who implements the will. Right?
Okay. What will be the role, sir?
Role is once the will is executed, then he comes and reads out the will and he distributes the property as for the will of the testator and hands over the property to whomsoever the beneficiaries are. His role ends with that.
Yes, sir. So he will hand over the documents or
not documents, sir. He hand over the document as well as the properties which are given under the bequest, sir, under the will.
Anyway, will is already registered. So
even if it's registered, he implements the will by handing over the properties which are given by bequest to various persons, that is the sons and daughters.
Okay, his role comes into play after the death of the testator.
Death of the testator. Or the
Okay, sir.
testatrix if she is a woman.
Yes, sir. One more question, sir. Kindly let me know whether Kauldar Nama in Telangana, is it compulsory or verbal agreement between
Sir,
the
please
landlord
remember,
and
sir, these days don't depend verbal, sir, because even if it's in writing, the question is question. Please remember, now the tenants get more rights than the landlords. You have to be always careful.
So what will be the duration, sir? Is it
No,
like
it depends on
20
you, sir. Either it's 1 year or 2 years or whatever it is. But what the coulter or the tenant does is he gives you about 10 bags of rice or 20 bags of rice plus some money. But one day he'll say, no, no, sir, there is no crop at all. There is no rain. There's no crop at all. Sometimes he swallows it. You have to always have a guard on these coulters.
Okay, sir. Sir, so it has to be signed by both the parties, sir.
Yes, sir, by the person who lets it out and the coulter who takes it on coul.
And registration, sir?
No, registration may or may not, sir. It's not necessary.
Okay.
Yeah.
Okay. And the duration is it 11
It depends on you, sir. Depends on you as a landlord.
Okay. Thank you, sir.
But you must have a periodical check over the Kaultar, sir, because I still remember my grandfather had extensive properties in Tanjavur. Everything is gone.
Sir.
They say once you have a guard to guard the fodder, when the guard himself swallows the fodder, where is the protection?
Confusion.
Better not to have lands now, sir, because the question is you are mostly an absentee landlord. What happens behind your back, no one knows.
Protecting property.
Exactly. Or have some family member like your brother or sister to look after it, and then you get your returns over it. Okay. And nowadays you're scared when the government will snatch away your property also.
Yes.
Because nowadays the SEZs and all are coming. So many economic zones are coming. Please remember, a day was there when you were very happy when your house on the main road. But today the GHMC comes and demolishes your compound wall and erects a new wall instead. About 30 years or 40 years go in that. Or let us say your land is acquired by the government for the metro rail project. Then the compensation is paid for you. You cannot question it. But the question is, quantum of compensation is normally under Section 18. You refer it to the subcourt and then fight it out saying that you must get more compensation than what is given by the government.
And the stamp duty, sir, 200 rupees, 100 rupees.
For what, sir? For what, sir?
For Kauldar Nama.
For Kaul Nama, it is, if you go by strict law, it is 3% of the annual rent, sir. But normally they take it on 100 rupees stamp paper or 200 rupees stamp paper. There's not much of importance to that. In our agency area, they call it as pauti.
Yes. Thank you.
Good evening, sir. This is Ram, Hyderabad.
Yes,
this
sir.
is regarding will, sir.
Yeah.
In what situations the will attains the nullity?
Sir, will attains the nullity for the simple reason the property which is bequeathed is not within the disposing capacity of the testator, number one. He doesn't have any document to support his title. What he does not have, he cannot pass it on. Second thing is, when the will is not attested by two witnesses as required by law, the will fails. And third thing is, when the will is executed not in a sound disposing state of mind, but when the testator is in his deathbed, any moment he will die. And his impression, thumb impression or signature is taken by force when he cannot even write or he cannot even put his signature. It becomes a suspicious document. Who says all suspicious are? We advocates only create it, isn't it, sir?
Thank you, sir.
I still remember, sir, one instance. What happened was an old lady was in the deathbed. Any moment she will die. And one of the beneficiaries came to me and said, sir, I'll pay you 30,000 rupees or 40,000 rupees. I'll take you to that place. We'll take the thumb impression of that lady. And the person who came to me was supposed to be the adopted son or something. Then I had a suspicion about it. I took the help of my doctor friend and said, you please accompany me and please examine him and examine that lady and say whether she is going to survive or whether she is in the senses. And this man gave me an opinion, sir. This lady is in a very, very critical condition. Even in 5 minutes, she will croak. Then what happened was I said, I don't want your money. I tore the will and said, I don't draft such documents because tomorrow your conscience pricks you somewhere, sir. They were just trying to hold her thumb with force and try to put the thumb impression. But the people who are nearby said, sir, she has got natural son also. Tomorrow if they come, this fellow will be in trouble. So be careful, sir. As advocates, we also owe a social responsibility, sir.
Sir, good evening, sir.
Good evening, Mr. Prasad.
Good evening, sir.
Good evening, sir. Yes, Mr. Murlidhar.
Now, rental agreements normally not registered and notarized. What is the sanctity of the notary? What are the actually?
There is no sanctity at all, sir.
Notarized?
Sir, before I
Why
even...
they are not there, their notary?
Sir, the question is, so long as it doesn't come to the court, no problem. But once it comes to the court, as per law, 3% stamp duty, stamps have to be purchased. It has to be engrossed on 3% stamp if it is for less than 3 years. Above 3 years, it is 5%. And it has to be registered because of now 17(1)(b) is also there. It says any transaction relating to immobile property has to be in writing and has to be duly stamped and registered.
So what are the then parts? Why the notaries are there, sir?
Notaries are there, sir. Just for I told you, that's why I said in Urdu, Miyan Bibi Razi hai to kya karega Kazi. The question is, suppose the landlord and tenant are in amicable and cordial terms, there is no problem at all. Unfortunately, what is happening is most of the corporate companies are going in for a agreement on a 50 rupee stamp paper or 100 rupee stamp paper, and the company secretaries who have to advise the company are not advising them properly. And once
notary documents, sir. Notary documents.
Notary documents are, suppose the property cannot be registered, sir. I take an example. Suppose you take the I told you the Indirama houses or 2-bedroom houses which are allotted. Then in that case, what they do is they take money and execute a document and get it notarized, because registration is prohibited as far as that is concerned. Especially this occurs regarding Leoni Pattas, Lavanya Patta as you call it. That is a land which is an assigned one and given to you. If you take the case of Ramoji Rao, who purchased that Ramoji Film City, that's also an assigned land. And you remember during the old regime of Y.S. Rajshekar Reddy, Undavalli Arun Kumar and Rajshekar Reddy was at the throat of the Ramoji Rao to see that the land is resumed, but that didn't apply. And that also applied regarding Padmalaya Studios also, and even Annapurna Studios also. Suppose it is given for a particular purpose, the government allows government land, and it is used for some other purpose, the government can resume the land at any time.
Yeah, that was problem for the Raghavendra Rao director also.
Exactly.
That he used for some other purpose.
The latest episode is Annapurna Studios.
Yes, sir.
And Padmalaya Studios, half of Padmalaya Studios was leased out to Z Telefilms.
Sir, in one case, because I came to know, I have seen also that the district court, 12 years ago, notarized document, they have taken stamp duty of 12 years, 24 years back, the stamp duty, and regularized the registration.
That is regarding this, what is called Sada Bainama. Sada Bainama. Sada Bainama, the government has given power under the ROR Act to collect the stamp duty and then regularize the document. It has become a regular document now. There is a regular procedure where the Tahsildar himself can do it. But now it's $1 million question, because the present government is thinking of scrapping the Dharani law, and I think Bhumi Chattam or something they're going to get, Bhumata Chattam. There, of course, the Dharani, I myself studied the Dharani. It was a lopsided act and giving rise to a lot of corruption and scams. Why? Because the old Pahanis, if you see, it contained 45 columns, but the Dharani, if you see, it contains only 3 columns, only to the name of the Pattedar. Name of the Akramanadar or possessor is not mentioned. So the question is, when suppose I like Mr. Murlidhar Bala, I can insert your name in the possessor column. Sir. That's how the government land was usurped during the previous regime.
Any more questions, sir?
Yes.
Yes, Sharma.
Hi, sir.
Hi, Sam. Please go ahead.
Yes, Mr. Sam. Yes, Mr. Sam. Good evening.
Sir, just related to what you have narrated about the incident, say if the will has to be modified, maybe the person maybe in 50s, and again after 20 years, he wants to execute a codicil, maybe
Yeah,
changes, modify the
supplementary document.
So, yeah. So in that, maybe signature, maybe his hand shivers or something.
Yeah.
I mean, because of its age and all.
Yes.
So in that case, can he do the thumb impression for the
That can be done, sir. Even the
Signature.
banks are also doing it, sir. Suppose there is a shake in your hand and you are not able to put your signature, the bank takes a thumb impression. Your wife or someone who identifies your thumb impression is asked to come whenever the money is drawn.
Okay. So because the parent
No, that doesn't get
that
doesn't get vitiated. The only thing is whether the strokes have come correctly or not. That will have to be seen. But the question is the earlier documents after attaining that age, what are the documents signed by him? Whether it bears the same signature or not, it can be compared and opinion can be taken, sir. Please remember, sir, we are not hale and healthy throughout our life. After when you are young enough, you have a clear hand, clear signature. When you become old, 2-3 years also, you develop a shake, and sometimes your signature also changes from time to time. You put different signatures at different times. You take my own case. I don't sign in the same way always. I sign in different ways also. No one can copy my signature.
Mr. Venkat Satyanarayana, please go ahead with your question.
Hello.
Yes, Mr.
Sir, good evening, sir.
Good evening.
Good evening, sir. For a leave petition, actually, for receiving documents, and the person, while filing the return statement, they failed to file their documents.
Yes.
So subsequently, it comes before court and file under Order 8.
Order 8, Rule 1A.
Yes.
Yes.
If for that, they have take leave. What is the meaning for leave?
Take leave means take the permission of the court and explain in the affidavit why you did not file it earlier or the documents were not available to you earlier, and the delay, if any, in filing them, we condone. That is normally the court does it. Liberally, they do it.
Actually, for this, they, along with the student document petition, they have to file another petition for leave.
No, sir, not necessarily. The same petition you can mention in the affidavit for leave.
Leave.
Yeah.
So,
but you must explain the reasons why it was not filed earlier.
If he not leave, he not mentioned leave anywhere or not mistake.
Even if it does not mention, sir, the court takes a liberal view. Subject to proof and relevancy, they take it.
Okay, sir. And one more question, sir.
Yeah.
If NRA executed GPA and stamp paper.
Yes.
For stamp 100 rupees stamp paper.
Right.
That is enough for in year 2016 and.
Sir, as for executing it on a stamp paper of 100 rupees, the question of where he executes it, whether in America or in India.
Actually, he is an American person. He came Hyderabad and he executed here.
He can mention it temporarily, come over to India and then get it attested, sir.
No, nothing, but there is no witness signatures.
Yes.
But he has to even give this his passport in and out exits, and with the visas, his supporting documents has to be submitted when a GP is given in India. That shows he's saying that he has come to India for his personal purpose or anything. These are all documents is mandatory.
No, but they not file anything. Simply
the only thing open to him is whenever he goes to America and all, he can get it validated get it signed before the consulate, and then come here the document comes here. Then go to the secretariat and get it validated. That's an authentic document.
Otherwise, you want to be basically
normally it cannot be acted upon, sir.
Actually, for basing on the GPA, the GPA holder come to the court and in the civil matter and prosecute the matter, trying to prosecute the matter. it is not permissible.
Then question is he has to file a
It-
petition under 32 and 33 civil rules of practice. Take the permission of the court to appear as a GPA holder based on the GPA. Then the GPA will be tested by the court, and then permission may be granted, may not be granted.
32 petition is allowed without seeing the document.
If it is allowed, you cannot question it later, but you can always cross-examine on that aspect.
But there is without having witness signatures, that can be valid.
No, sir. GPA doesn't require witnesses, sir. But for safety's sake, we do it because for execution.
But whether he is executed or GPA holder himself
Yes.
taking a
See, if you see, there are Supreme Court judgment, and as far as judgment of our AP High Court long back, Hanumantu judgment is that a GPA holder cannot depose on behalf of the principal.
Yes.
Yeah.
Okay.
Mr.
Okay, sir.
Right.
That is there, my brother. But,
Yes, sir.
but the question is, but he is not for that GPA is marked as exhibit.
Once it is marked as exhibit, you can definitely question.
I have questioned. I have questioned that the document won't be marked. Remove the marking of the demarcation.
Yeah. Order 13, Rule 3.
Yes. Because there is no signature, whether he is there is a doubt on the document.
Yes.
So that is the pending before the court.
Sir, unfortunately, our courts do not have that IQ which we people have, sir. I'm sorry.
On options of the opposite party, they mark it.
They do it, sir. I tried that same thing to unmark it. But the court said once it is marked under 35 and 36 of the Stamp Act, it cannot be questioned. There are various judgments on that.
Yes, sir.
Yeah.
Okay.
Right? Right.
Mr. Koteswara, please go ahead, sir.
Yes.
Mr. Koteswara.
Mr. Koteswara, Mannam Koteswara. Mannam Koteswara.
All right, Mr. Ramesh.
Ramesh Kumar.
Sir, this is Koteswara, sir.
Yes, sir. Tell me, sir.
Sir, after the demise of testator, the legatee will get rights over the properties that are mentioned in the will.
Yes.
So the legatee can sell the properties after getting the rights.
Once he gets the rights, the only thing is he has to get his name mutated in respect to the property where he has got the bequest. And once he gets it mutated under the will, he can sell the property. He gets absolute rights.
Okay. Right. Based on the will itself, we can go for the mutation.
Based on the will.
Okay. Yeah. Then what is the role of letter of administration, sir? Here it is.
Letters of administration is if it's a Christian will and it is registered, to put the official seal of the court saying that it's a genuine will of so-and-so, and it can be relied and believed in all matters, and the official seal of the court is put on that to give effect to it. That is called letters of administration.
It is for Christians only.
Only Christians.
Okay, thank you.
Mr. G. Ramesh Kumar Guru.
Mr. Ramesh Kumar. Mr. Ramesh Kumar. Mr. Ramesh Kumar.
Hello.
Please, go ahead.
Sir, good evening, sir.
Good evening.
Sir, in Telangana, Poti and Virasity is one and
No,
the
sir.
same.
In Telangana, they don't use the word Pauti, sir. It's used only in the agency area, that is Srikakulam, Vizag, and other places, sir. Not in Hyderabad. Not in Telangana.
In some Pahanis where referred it as Poti.
Even if it's Pauti, it has to be understood as cowl only.
Okay, sir. Thank you.
Right. Yes,
Mr. Ramakrishna.
Ramakrishna Garu.
Sir, good evening, sir.
Good
This
evening.
is regarding will. Under Hindu law, is it required to probate the will? What is the time limitation to probate the will?
There is no necessity to probate a will in Hindu, sir. But one thing is this, if an executor is there who questions the implementation, like I told you also, ask the bank not to make the payment to the beneficiaries till they hear from him, then in that case, the executor himself can file the OP before the court for probate and ask the court to give us official sanction and to give effect to the will and implement the will so that the executor may distribute the money, sir.
Sir, if there is no executor?
If there is no executor, straight away it can be distributed according to the terms of the will. But one thing is this, the question of probate is not necessary as far as Hindus are concerned. Second,
thank you, sir.
Yes, sir. Yes. That's it?
Yes, sir. One question
Mr.
from me.
Prasad Rao. Yeah.
Yes, sir. Can an advocate sign as a witness, sir?
See, an advocate, as far as possible, should avoid signing any document as an attestor or as an executant. As far as his property is concerned, he can do it. But as an attestor, please remember, you cannot appear for that party if you sign as an attestor.
Okay. Taking forward the example you have given.
Yes,
like
sir.
somebody is at the final stage of the...
Exactly. And in the Advocates Act, an advocate also cannot bid in the court auction. But most of the advocates bid in the auction through proxies. A judge cannot bid in the auction, but judge bids through his proxies.
Sure.
Right?
The example which you've taken earlier,
yeah,
like somebody was not well at the final stage and they asked you to...
Exactly, sir. What happened was that lady was 99% dead, sir, mentally dead. But the beneficiary, who was the adopted son, wanted a will from that lady under any circumstances. He took me there and tried to get hold of the thumb of that person who was almost sinking and put her thumb impression. But I took the assistance of my doctor friend and took him there and asked him to examine. He said, sir, don't do it. It's dangerous. This lady will not live even for 5 minutes. So the question is, we have to guard ourselves. Just because of money, we shall not sell our conscience, sir.
Yes, sir. So same example, for example, if this case was taken to a registrar,
yes,
somebody has taken a last stage person to the registrar, and then they ask the registrar to register the will.
Yes.
Before the registrar.
Yeah.
Can the registrar say the same reply like you said?
Sir, registrar, normally there are two methods open, sir. Either you can take the testator or the person there and get it signed, or you can ask the registrar to come to your house where that lady stays, and the registrar also will be suspecting, because the question is, he'll also see the lady's condition. He'll refuse to register it.
So registrar can refuse?
Yeah, he can refuse.
Yeah. Suspicious.
I think the questionnaire or the interaction is over. Tomorrow we shall discuss about the drafting and pleading. I just gave you an introduction. I'll come to that, and in the end we'll go to the professional ethics, please. Thank you very much.
Thank you, one and all. Thank you very much.